Number 3, Vargas versus Deutsche Bank.
Your Honor, it's asking me to restart my video. I don't want to waste the court's time. Could I appear by audio only?
Certainly you may. If you're comfortable with that, the court's comfortable with that.
Yeah, I'm not much to look at. Your Honor, may it please the court, my name is Patrick Broderick. I'm here for the defendant appellant, Deutsche Bank National Trust Company, and I'd like to reserve 2 minutes for rebuttal.
You may, Mr. Broderick.
This case deals with the acceleration or alleged acceleration of a mortgage loan. And as has been discussed this afternoon, acceleration requires clear and unequivocal notice of that acceleration to the defaulting borrower. Here, the letter that was sent to the borrower indicated that the lender will accelerate your mortgage with the full amount remaining, etc. And the First Department found that the saying will accelerate is an acceleration. We respectfully submit that saying that an actor saying that they will take an action is not the same as actually doing that action. We also submit that looking backwards, in this case years later, at a document saying that an action will be taken is not proof that that action was taken. In this case, the First Department, however, found that a letter that said that the mortgage loan will be accelerated was the acceleration, and that the acceleration took place on the 33rd day after the date of the letter.
Chief Judge, may I ask a question?
Yes, Judge Stein.
Counsel, there's a lot of focus on the word will. Assume for the moment that will, that term itself is sufficiently unequivocal. I guess I have a problem with that letter because I can't tell when the letter is saying that it would become effective. In other words, it says that, you know, the expiration of the cure period or commencement of a foreclosure action, and it refers to at that time. So at which time? Is it clear enough? Is that a problem as well? I guess that's my question.
Your Honor, we think that's a gigantic problem, and that maybe the word will, I don't think it's unequivocal, but it's certainly not clear. And certainly the language at the end of that same sentence saying at that time, at what time? Is it at the time after the expiration of the 32 days? Or is it at the time of the filing of the foreclosure complaint? Or is it the time when the lender, by some other means, elected to exercise its option to accelerate?
Can I just clarify one other thing? It's hard to tell from your brief, but I just want to clarify whether, are you conceding for our purposes here that that there was standing to commence the 2009 action, and therefore that would accelerate the debt? Or are you just saying that it doesn't matter because even if it was accelerated in that action, it was subsequently revoked?
The latter. We hotly contested whether or not the 2009 foreclosure case accelerated the debt. And at the trial court level, what happened is after the motion to renew, the trial court said, well, I don't have to get into this, whether the foreclosure complaint was brought by the proper party, because I have a letter here under the First Department jurisprudence, under the Royal Blue Realty case, that letter accelerated the debt. And so the trial court kind of didn't pass on that issue. We would respectfully submit that that is an issue that has not been determined by the lower courts. So we are not stipulating that the 2009 foreclosure complaint operated to accelerate the mortgage debt.
Thank you.
Looking at the letter, it's clear that a couple of things jump out. In addition to the will language is referring to an affirmative act by the speaker. In other words, it says we, which is referring to the lender, we will accelerate your mortgage. Well, that's a statement of future intention. In other words, consistent with the Second Department's decision in the Malone case, it's a future intention to take an action. the action in this case would be to accelerate the loan. It even says, we will accelerate your mortgage. Not that it is accelerated, but we will accelerate your mortgage at a future date. And as the second department held in Malone, a future intention may always be changed in the interim. And we think that sentence is critical in this case because it's demonstrably true. When you say you will do something, it's not the same as actually doing it. You can change your mind in the interim, or it could become impossible for you to act in the interim. What it's not doing is actually taking that action. It's not automatically self-effectuating. And for that reason, we think the second department holding in the Malone case and the Adamez case before Malone, we think are the controlling cases on this issue. Here we have a letter that does say we will accelerate, but it does not say when. It does not say that it is automatic and does not provide an amount of that acceleration. From the point of view of the borrower, when you owe someone money, the two most critical pieces of information are, number one, how much do you owe? And number two, when do you owe it? Here, the accelerated amount is not provided in this letter. In addition, it says we will accelerate.
If I may ask a question, Judge, Mr. Broderick, I mean, isn't the point of acceleration you owe everything on, I'm calling in the debt.
That's right. That is the point of acceleration.
So I don't know that that's really the issue. I take your point about the possibility that the lender could change their mind, even though, as the letter is written, it appears on its face at least to put this within the hands of the debtor. You pay, we're not going to accelerate. You don't, because now the default has been addressed. You don't pay, we're going to accelerate. But I take your point being that the lender might, for whatever reason, even if there's not a payment by whatever date is selected by the lender under the law as appropriate, that the lender might choose not to accelerate. Is that sort of where you're going with this argument?
That's exactly right. That the acceleration will occur at a future date that has not been determined and is not apparent from the face of this letter.
So then your view, I take it, is that as a result, you are encouraging, through that understanding of the letter and the language, it encourages the debtor and the lender to work it out. Am I understanding you correctly? Because there's still hope from the debtor's perspective that they could avoid this acceleration.
That is exactly right, Your Honor. We think that that this language, which is consistent with the mortgage contract, is also consistent with public policy, in that by not finding an automatic acceleration with language such as this, it avoids a race to the courthouse by lenders. And in fact, it encourages the two sides to get together. And in fact, the second page of the letter actually encourages the borrower to telephone in to loan resolution to try to work this out. And so rather than being a clear and unequivocal acceleration of the debt, this is simply a letter that is encouraging the two parties to work it out, and that is complying and gives only the option to the lender to accelerate in accordance with paragraph 22 of the mortgage. Moving on.
Thank you, counsel. Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the court, Justin Pane for Respondent Juan Vargas. Before getting into what I believe the court would like to address is how to tackle this will language, I just want to make clear in Mr. Vargas's case, Deutsche Bank itself admitted 5 times in the record that the loan was in fact accelerated as of January 16, 2009 at the latest, and that the loan was still accelerated more than 7 years later in April of 2016. So just to be clear, the record clearly establishes that this loan was accelerated for a period of 7 years. So regardless of what statute of limitations applied in this situation, by Deutsche's own admissions, 3 of which being under oath by its attorneys, by its own admissions, Mr. Vargas demonstrated his entitlement to judgment as a matter of law. Now, whether or not we go into now the will accelerate, which again, I look forward to making this argument on why this was sufficient, but to be clear, the facts of this case, just in a closed box here, Mr. Vargas proved his burden. He established the loan was time barred, and it was based off of Deutsche's very own admissions. Having said that, going into the will accelerate,
Well,
the language, go ahead.
it doesn't that ignore any argument about possible revocation in there? So that it could have theoretically been an acceleration, a revocation, and then another acceleration. So don't you have to talk about the revocation also?
Only if the Deutsche had argued that it decelerated by revocation and then reaccelerated. Nowhere in this record will the court find Deutsche making the allegation that after it decelerated, it then reaccelerated. It never makes that argument.
But
So
isn't that the automatic result of the action if it was revoked, and then there's something that came afterwards? Isn't that just sort of an automatic conclusion?
no, I mean, this case is proof that in the Angle and the Nadu cases that deceleration does not discontinuance does not automatically equate to deceleration because
Okay, well, that's the question of whether there's been revocation, and that's the question that I'm trying to get you to talk about a little bit.
Okay, revocation, I don't believe there was, just because factually the record shows the loan was still accelerated after this revocation. And again, the revocation clearly from the circumstances shows that Deutsche had an ineffectual judgment. It submitted falsely affirmed affidavits or affidavits it could not confirm were true. And the trial court in the 2009 foreclosure action said, well, we're not going to grant you a renewed judgment of foreclosure because you submitted false affidavits to my court. So in the discontinuance papers, Deutsche admitted itself that the sole purpose of the discontinuance was for the recommencement of foreclosure proceedings to pursue a valid judgment. But again, going back to that discontinuance, meaning revocation automatically or otherwise, this particular record proves that after the discontinuance, and while no foreclosure action was pending, that's an important point to make, is that the record shows the loan was still accelerated as of April of 2016, and there's been no foreclosure action commenced ever since 2009. So
Judge, if I may ask counsel, so counsel, if I'm understanding you correctly, your argument here is if we agree based on the prior cases with the Second Department's approach that a discontinuance in and of itself, without, if it's silent on the issue of deceleration, doesn't decelerate, I assume you're saying you win. But if it's an automatic, right? If it's an automatic revocation, you're saying yes, but if they are able to make a decision not to accelerate through their actions, through an overt act, the overt acts exist here because for the entire period of time beyond the statute of limitations, they were seeking to have Mr. Vargas pay the entire amount. Am I getting your argument?
I hope I'm answering your question correctly because it's a little bit long, but
I'm known for that. My apologies.
well, what Mr. Vargas is positing here is that this case proves that deceleration in and of itself does not automatically, revocation or discontinuance does not in and of itself automatically decelerate, because this record shows that even after discontinuance, Deutsche was still treating the loan as accelerated. And that's the record at 300.
I think you're arguing that even if we adopted such a rule, that it is automatic, that in this case, the lender actually wasn't seeking acceleration. Right? Their intent was, deceleration. Their intent always was to continue demanding the entire amount.
Correct, and the record proves that fact. So that would kind of go back to how it would be tough to adopt such an argument, whereas one of the cases before the court on the argument shows that it's not automatic and that it couldn't be automatic, because in some cases it's the lender chooses to keep the loan accelerated. So again, on the facts alone, this record shows that the loan was accelerated for a 7-year period and that it was not revoked. Now, on the issue of will accelerate, I believe the letter
So if I can follow up, then why couldn't the court adopt a bright line rule that makes it easy in this way? The discontinuance is an automatic revocation, but the debtor may rebut by showing that indeed, on the facts of their case, the debtor did continue to pursue the entire amount?
I believe the bright line rule would make it extremely difficult then to ascertain any specific accrual date, because now you'd have to ascertain, or you'd give the lending institution an inference that they were able to decelerate and that it was timely without establishing when they did accelerate. And then you'd put it on the borrower to then establish that it was on them, even though the lender has all the facts, to tell the court when it was accelerated, that it wasn't decelerated, and give particular dates, which again, as the defense burden to prove statute of limitations expiring, I believe you've given defendants an unreachable goal. I don't think any defendant could meet that standard ever.
Chief, may I follow up on that for a moment?
Yeah, Judge Wilson.
So counsel, suppose the rule instead was an automatic deceleration upon discontinuance, but the next time the lender sends something saying, I want the whole amount, that then is a acceleration by letter. Doesn't that give you that a clear rule about when the reacceleration started?
I'm not sure that it does. And I think this kind of piggybacks off the question you had asked in the last case regarding the general rule, where you had a tough time saying if a lender elects to accelerate that, or I'm sorry, doesn't choose to exercise their election to accelerate, are we to say that the cause of action just accrues against them even if they don't elect it? Am I correct in saying that's a piggyback off the question you'd asked in the last case?
I don't view it that way, but that doesn't mean you couldn't.
Okay, I wanted to make sure I'm answering your question specifically, but I believe that if your question is that
Would it help you if I try my question again?
it would be wonderful, thank you.
So let's suppose that we adopt a rule that says a discontinuance voluntary, not on the merits, discontinuance of the action automatically causes a revocation of the acceleration. That's a hard, bright line rule. But we also say you can, if you're the lender, accelerate a loan by starting an action, but you can also accelerate it by sending the borrower notice that you are accelerating the loan, that you have accelerated it. Maybe not that you will, but that you have. And if the lender sends something saying after the automatic deceleration, sends something saying you owe us the full amount, that is then starts the acceleration again. Could we have that kind of rule? Wouldn't that take care of the lack of clarity issue you raised in answering Judge Rivera?
I'm not sure that it would, because if you have this voluntary discontinuance acting as automatic revocation, well, then you're saying that if the election was made in the complaint, okay, I can understand how it makes sense, but if the election to accelerate was made prior to the complaint, now you're saying that the deceleration or discontinuance vitiates any prior act of acceleration, regardless of whether it was through the commencement of foreclosure or by notice earlier on. So you're now opening this Pandora's box to how far in a continuum of time this can go. But let's just go with that thought. Let's say, okay, the discontinuance is automatic, and then a lender can send a letter saying they're reaccelerating. They absolutely can reaccelerate the loan because it's on the defendant to raise a statute of limitations defense. I mean, it's a waivable defense. So a lender can seek an accelerated, balance, 15 years in the future. If the defendant doesn't raise the defense, they get the 15 years worth of payments. So it's on the defendant to raise his defense, but I'm not sure, I guess I understood the automatic revocation then leading to a reacceleration by letter. I mean, again, I think the letter is an easier way to fix a statute of limitations period or accrual. And this is what I guess I was trying to address in your last question, is that the lender does not have to send under a Form 3033 Fannie Mae mortgage, does not have to send a notice of acceleration. If a borrower misses a payment, the lender could start a foreclosure action on the one payment. New York RPAPL provides for partial foreclosure actions. So if they wanted to, they could foreclose on a single payment, 2 payments, 3 payments. But if they want to elect that special rule where they can say, you know what, this loan's mature now, I'm maturing this loan due and payable in full, they have to send out this condition precedent notice of acceleration. And in this particular case, rather than use what the mortgage said you're supposed to use if you're a lender, it says you have to send on the paragraph 16C and 22B4 that if I do not correct the default by the date stated in the notice, lender may require immediate payment in full. In this case, IndyMac chose not to use the language in the mortgage because the borrower and IndyMac agreed that the language would be may accelerate. It chose to supplant that with the word will. So again, we have to give effect to the meaning of the negotiation maybe between the borrower and the mortgage bank on making this contract, is that they both agree that may would be the operative word to say, we don't have to elect it. We're just going to maybe in the future, and that would be equivocal. And I agree, may accelerate would be not sufficient. By choosing will over may.
Thank you, Mr. Payne. Mr. Broderick, we're
Thank you, Your Honor.
assuming that you've maintained, you're welcome. We're assuming you've maintained your connection.
Yes, Your Honor. Can you hear me?
Yes, we can. Thank you.
Thank you, Judge. Just briefly, I just want to speak about the alleged evidence that subsequent correspondence on the record here somehow evidences acceleration from by the August 2008 letter. There's two letters in the record that I think counsel was referring to. The first letter was sent by a law firm during the pendency of the foreclosure case. That letter is on the record at page 37. It's during the pendency of the foreclosure case when foreclosure counsel was under the mistaken belief that there was a foreclosure pending, number one. And number two, that a valid foreclosure was pending, I should say. Number two, it does not refer to the word acceleration. It says nowhere in accelerate that it's an accelerated amount, and it in nowhere refers to the August 2008 letter, which is the one we're talking about at issue in this case. So we don't think that letter in September 2013 evidences anything with respect to acceleration. The second letter in the record is after the foreclosure case was dismissed. That's at the record at page 39. That's a payoff letter. Payoff letters have nothing to do with acceleration of loans. Loans that are current, people can and do ask for payoffs if they want to refinance, if they're selling the home, etc. Payoff quote has nothing to do with acceleration. The letter itself that's being referred to in July of 2014 never mentions acceleration and certainly never mentions the letter from 6 years prior saying that that was the acceleration. So we don't think the record subsequent to the sending of the letter in August of 2008, we don't think the record bears out the argument that the loan in fact was accelerated by that August of 2008.
Judge, can
Yes,
I ask
Judge
a question?
Fahey.
Mr. Broderick, what would you have us look at in the record? What would you point to? What piece of proof would you point to that you would say this letter constituted a deceleration of the loan? What in the record?
We would refer to we start by saying we don't think this loan was ever
Okay, I got
accelerated.
that, but let's assume it was accelerated. What would you point us to say it was decelerated?
We would point to the motion to discontinue the action.
Thank you.
Thank you, counsel.